Okay, we are going to go on the record here. This is case CR 22-21-16-24, State versus Lori Vallow, aka Lori Daybell. This is the time we have scheduled for a hearing. The state filed a motion to modify or in the alternative to extend the court's protective order. And for starters, I'll indicate there was a protective order issued in this case, and it was filed under seal, and that was issued on July 15th, 2021. Courts reviewed the contents of that order, and pursuant to Idaho Court Administrative Rule 32I, the court does find that for purposes of this hearing, counsel may refer to and mention the order or the contents of that order. Even though it's under seal, the court will make a determination that won't violate the terms of the order sealing the protective order, as it's the subject of today's proceeding. If we need to go into any of the specific details or allegations that led to the issuance of a protective order, the court would ask that that be done in camera on the record, but outside of the public's view in a closed portion of the proceedings, if necessary. Appearing today for the state is Lindsay Blake, who will be arguing the motion. On behalf of the defendant is Mr. Archibald. And I understand, Mr. Archibald, your client is listening in telephonically to this hearing. Is that correct?
Yes, Your Honor.
Okay, thank you. We are conducting this hearing by Zoom remotely. It's also being live streamed on the court's YouTube channel for public access to the hearing. And so I will bring up another part of this motion. It was filed on shortened notice on December 29th. And so we're having a hearing on shortened time frame. I wanted to ask Mr. Archibald if you object to the proceedings going forward today on shortened time as requested by the state.
Your Honor, when they asked if I would be okay with setting this within the time frame, I said yes, that's okay to set it quickly. I still do intend to object to the contents of the motion, but I'm okay with proceeding.
Very well then. On the motion for request to shorten time, the court will grant that, and we will proceed forward with the substance of the hearing then today. So the state's filed the motion, the court's reviewed that. I understand Mr. Archibald has an objection to the motion. So Ms. Blake, if you'd like to offer argument in support of your motion, you may.
Thank you, Your Honor. The state did file a motion to clarify or in the alternative to extend the court's protective order, which was put in place pursuant to Idaho Rules of Criminal Procedure, Rule 16 specifically, and specifically subsection L. The state had previously filed a request or a motion for a protective order to be put in place with regard to the discovery in this case. There was later a hearing regarding that motion with regard to the case number applicable to Chad Daybell. That order was essentially modified with regard to that case number. However, it's the state's understanding that that protective order remained in place specifically with regard to Mr. Means in Ms. Vallow's case. That motion was supported by a sealed declaration or affidavit under Idaho Criminal Rule 16L or Rules of Criminal Procedure 16L. The requirement is that declaration remains sealed if the protective order is granted. So the state did not intend to get into the details of that declaration today, specifically because it is sealed and has not been provided publicly or to counsel at this point. It's the state's understanding that this court had reviewed that in making the determination to keep the protective order in place with regard to Mr. Means. It's the state's position that this court has broad discretion when determining issues with regard to discovery and whether or not there should be a protective order in place to protect the integrity and the fairness of all parties or the right of all parties to a fair trial. The state's position is that authority of the court over the discovery, the protective order, and or potential dissemination of those discovery materials remains within the court's purview and control, whether or not counsel is active in the case. So the state had initially, this is a two-part motion the way it's drafted, because it would be the state's position that that protective order actually is still in place, and we simply wanted to clarify that. And specifically with the additional hearings that happened with regard to the protective order, it's specifically in place with regard to Mr. Means. The state's position is it does not matter whether or not he remains counsel of record, that the court maintains discretion and control over that protective order. And we would just ask to have that clarified. If in the alternative, the court does not view that as currently being in place, then we would be asking the court to consider expanding or extending that order, continuing forward. In addition to that, the state would note, and the court is probably aware, there have been certain discovery materials that have been disseminated or disclosed that relate to this matter. They were not disclosed specifically here in Idaho, but have been disclosed in other jurisdictions or in another jurisdiction. However, it is still the state's position that given the voluminous amount of discovery in this case, there is still a significant amount of discovery materials that have not been disclosed or disseminated to the public, and that it would not be in the interests of any party's right to a fair trial if those were to be disclosed. Specifically, there are some very sensitive documents that have not been disclosed. Again, based on the protective order being in place, the state did not intend to specifically list any documents. If the court felt that it was necessary or important for the court to know what some of those documents are, I think the state would request to discuss that in chambers and then make a determination whether or not the court wants that placed on the record. But that would be the state's position with regard to that. I think in addition to that, Mr. Means has an ongoing obligation based on the court's recent order with regard to removal of Mr. Means from this case. There was a finding that he had represented both Chad Daybell and Lori Vallow Daybell. So it's the state's position that he has an ongoing ethical obligation as well to both of his former clients under Rule 1.9. And we think the court can take that into account as well in determining the appropriateness of continuing forward with this protective order to ensure the integrity of this case and the rights of everyone to a fair trial. In addition to that, with the court's most recent order and some of the issues or concerns that were addressed in that order, and the state recognizes some of the state shared in those same concerns and had raised a lot of them in response to some motions filed by Mr. Means. But specifically what the state is referencing or looking at is the concern regarding Mr. Means filing documents under penalty of perjury and documents that specifically referenced or at least alluded to conversations he may have had or did have with his client, Ms. Vallow Daybell. The state has concerns, shares the court's concerns regarding those and the potential for Mr. Means to become a witness in the case. So we would ask the court to consider looking at Rule 1.9, and the court had previously referenced 1.7 in the court's prior order, whether or not some kind of an additional order prohibiting or restricting disclosure of any conversations he may have had with Ms. Vallow Daybell and or discussion of the most recent pleadings that had been filed where that was referenced. The state believes it may be prudent for the court to look at entering some kind of an additional order. We wanted to raise that concern and leave it in the discretion of the court. The state does not believe anything has changed with regard to the protective order and the need for the protective order or the potential negative ramifications and implications if that order is lifted with regard to Mr. Means.
Let me ask a question here, Ms. Blake. The protective order, in effect, relates specifically to documents in discovery and information in the case. I guess the concern I have is what's being raised here. To me, seems like you're asking for what I would consider a gag order, where in your motion is requesting that I order that he be prevented from public comment, for example. And as you just mentioned, from essentially talking about the case, which to me, that's a request for a gag order, which is certainly different than the order that's in effect that only relates to discovery in the case. So is the state asking for a gag order here?
We are not, Your Honor, and I guess I should be clear on that, and maybe I'll clarify that a little bit better. We are asking that the court clarify whether or not the current protective order that has been granted specifically is currently in place with regard to Mr. Means that is applicable under Rule 16L. We're asking for clarification that that remain in effect. If the court did not see it as remaining in effect right now, we would be asking to expand or extend that order to continue to remain in place with regard specifically to Mr. Means based on the attached declaration that was filed with the state's motion and the rationale provided in there. And then so that was kind of a two-part argument. And then the third part, and I think I called it a two-part argument, but the third part would be the state just wanted to essentially address our concerns and join in the concerns addressed by this court in the most recent order regarding those communications. We are not specifically asking for a gag order. We wanted to raise the concerns that the state had and then leave it in discretion of the court whether or not any kind of an additional order is appropriate. I think in our motion, we'd also specifically outlined the state is not asking for a gag order, generally speaking, because we have indicated in our motion, and it would be our position, that we do think if at any point the court ordered or the court authorized Mr. Means to talk about any of the discovery materials under the protective order that was put in place under Rule 16L, and or if the court did create any other kind of an order restricting Mr. Means' comment regarding conversations he's had with his client, that would still be in the court's discretion to allow those comments to occur. The state is not trying to become the micromanager of those. We just had concerns and felt it was more appropriate if the court and or current counsel, Mr. Archibald, if one or both of your permission were required for any kind of disclosure regarding the discovery materials, and then separately, if the court does enter any additional order regarding restriction of conversations, that then the authorization be required from the court and or Mr. Archibald for those to be made public or for public comment to be made regarding those matters.
Okay, well, thanks for your clarification on that point. Mr. Archibald, what is your response to the state's request?
Your Honor, I was not involved in the case when the initial protective order was put in place by Judge Watkins in July of 2021. I've seen the order. I don't know the reasons for that. I know there are rules of disclosure of grand jury transcripts, particularly Rule 6.2 of the Idaho criminal rules. So I have received the grand jury transcript. My client has not seen it. I intend to make a copy of it for her and so that she knows what the evidence was that indicted her on these charges. But reading the protective order by disclosing the grand jury transcript discovery information to her, that could potentially be a violation of this order. And so I certainly don't think the court can impede in my ability to get discovery materials to my client. And the reason that could be a violation is because they won't be in her possession. She can read them. And then because she's at the state mental hospital, then she would have to turn those over to the custodians there, and then they would safekeep them for her. So in that respect, this protective order is complicated in that other people will take possession of these materials for my client. I'm objecting to this modification of the protective order in part due to their mostly asking for prohibitions on Mr. Means. And Mr. Means, as former counsel, was not served with a copy of this motion, was not notified of this hearing by personal service. He's not a party to the case anymore. And so, yes, he knows about the state seeking additional restrictions on him, but it is unfair for the court to put an order on him when he's not a party to the case. Attorneys owe their clients duties, both current clients and former clients. They owe them duty of loyalty, a duty of confidentiality, and all of us attorneys have those duties to our clients, whether they're current clients or former clients. And so Mr. Means is still under obligations to Lori Vallow to be loyal to her and to keep her secrets confidential. And he knows of those duties, and he should respect those. And so in proceeding with this hearing today, to clarify this protective order, it would be improper, I believe, for the court to issue orders impacting Mr. Means when he's not part of this hearing. The information in this case is voluminous. I agree with the state. There has been so much information produced by who? By Lori Vallow or her attorney? No, it's been disseminated to the public by law enforcement, by both Idaho law enforcement, by Arizona law enforcement, by Utah. And the court knows about that. The court knows about that because of the change of venue hearing. The court has been able to see all the media publicity about the case. And did that information come from the defense? No, it came from the state or other state jurisdictions. And so to continually try to ramp down on the defense as though we're doing something wrong is, I believe, misguided. But because the court has heard the change of venue evidence, the court has ruled on that. The court has transferred venue because of that. And so any further restrictions on defense of dissemination of information, I believe is not justified. And so there haven't been any violations, I don't believe, of this order since July. And so for the past 6 months, this order has been complied with. So I don't see the point in making further restrictions on the defense. It's been abided by. There haven't been any motions for contempt or sanctions against Mr. Means or the defense. So I don't believe this motion is well taken. So for those reasons, Your Honor, I object.
Okay, thank you, Mr. Archibald. Ms. Blake, anything you'd like to say in response and rebuttal?
Yes, Your Honor, and I'll try to keep this brief. As the state indicated, when we filed this protective order, or I guess we didn't make this clear, when the motion for the protective order was filed, it's the state's recollection that Mr. Archibald was not counsel of record at that time. As I indicated, there was a hearing held regarding the state's request for the protective order, and essentially the state's understanding and interpretation was the order remained applicable to Mr. Means based on the sealed declaration that was attached to the state's motion. The state does recognize that Mr. Means was not served and a copy of the state's initial motion for the protective order or the declaration, but that was done pursuant to the requirements of Idaho Criminal Rule 16L. It specifically indicates it's an ex parte motion and that the declaration will remain sealed if it is granted. So the state also recognizes that Mr. Archibald has not had an opportunity to review or see that declaration. The state's position on that is we are simply complying with Rule 16L If the court believes that it has discretion or authority and Mr. Archibald needs to review that, the state would leave that solely in the discretion of the court. The state's, additionally, we want to make clear we're not asking for additional restrictions under Idaho Criminal Rule 16. We are only asking to have that remain in effect, whether or not that's just clarifying that it does remain in effect, or whether or not it needed to be extended or expanded to remain in effect. But we're not asking for additional restrictions outside of what are already in place with regard to the disclosure of any discovery materials or information. Further, the state does not believe at this point that that protective order has been made applicable to Mr. Archibald, or that he is bound or restricted under that. I think that would require some additional findings or restrictions to be put in place by the court, and the state is not asking for that at this time. Again, it's a situation where the state's rationale and reasoning is provided in a sealed declaration that we are not getting into the contents of today. So we reference back to that with regard to why the state had requested that. And I believe that was the rationale for the court keeping that in place at this point in time, or it initially being granted by Judge Watkins. The only additional concerns raised by the state today are based on some argument made by the state previously, the court's most recent order removing Mr. Means from the case, and the state wants to make clear we're not specifically asking for additional orders. We simply wanted to address that the state shared the same concerns and wondered whether or not the court felt an order would be appropriate and wanted to raise that potential concern there. But we're not specifically asking for any specific order, just raising that as a potential concern. And if I can have just a moment, Your Honor.
Yes.
And that's it for the state, Your Honor. Thank you.
All right. Thank you, Ms. Blake. Well, the court's reviewed the motion, which, as has been mentioned, was prayed for in the alternative. I've reviewed also the order, which was issued by Judge Watkins on July 15th, and looked at the terms of that order. The order, as it's written, I think serves to be in effect as to both Mr. Archibald and Mr. Means as written, and because of the broad language of the way the order was written, I'll just cite to the first one of the sentences in there. It is ordered that no one having access to the discovery in this matter, including but not limited to the state, the defendants counsel, employees, etc. So I think the terms of this order cover both current and former counsel for the defendant, wherein obviously Mr. Archibald is currently defendant's counsel. Mr. Means is prior counsel, but he is still someone that is included but not limited to, if we use that language, someone who has access to the discovery in the case. And so I don't see a reason to need to expand the order. And my concern I had, as mentioned, was whether the state was seeking some sort of a gag order against Mr. Means. And if that were the case, then Mr. Archibald's arguments about him requiring notice of any such proceedings and an opportunity to be heard would come into effect. So the court will simply grant the motion clarifying that based on the language of the existing order, the order does not need to be modified or amended, but the language includes the restrictions as they apply both to Mr. Archibald and Mr. Means, and that order continues in effect in the case. With that being said, Ms. Blake, there was a concern raised that perhaps the order was in fact too broad, and Mr. Pryor raised that in his case, in Mr. Daybell's case, that the way the order was written, it appeared potentially he couldn't even have office staff and others having access to the information to assist him with the case. So I recall that issue coming up. I don't recall that we modified the order in that other case. And if you'd like to clarify that, I think the order is clear that discovering this case is not to be disseminated outside of the attorneys working on the case and those necessary to assist them. But it doesn't need to be so broad that, for example, if Mr. Archibald has an assistant helping transcribe something or work on something, that he needs to get a specific order from the court to not run afoul of the terms of the order. So I know we had that discussion previously. And if anything, I'm wondering if I need to potentially clarify the order to make it a little less restrictive to allow Mr. Archibald to proceed without worrying that he's going to violate the order by doing his job. So your thoughts on that, Ms. Blake?
Your Honor, the state has no objection to that. The state's recollection was when we had the hearing at Mr. Pryor's request that the order was actually modified on the record. I thought that Mr. Pryor had followed it up with a written order indicating such, but I think we had a similar discussion on the record regarding the potential to discuss it with certain defense witnesses or experts or staff, and the court did relieve or modify the protective order with regard to Mr. Pryor and the state at that time. I don't recall that Mr. Means made argument on that motion. He may have, but if so, I do not recall that. But either way, the state does not have an objection to modifying that protective order to allow Mr. Archibald to speak with staff experts who he needs to regarding the case. And obviously, specifically with regard to his client, he should be able to go over discovery with her. And I don't think the state ever had an intent for the order to restrict that counsel's ability to discuss the case or discovery with their client. So if the court needs any additional information or clarification, the state's happy to provide that.
Okay, thank you for that. I looked back through Mr. Daybell's case and did not see where we actually entered a modified order. So perhaps that's a matter of housekeeping I need to take up in both cases. But Mr. Archibald, so I think the order should be modified to the extent that it doesn't cause you concerns when you're working with staff and others that need to have necessary access to this information. So based on all that, I'll grant that part of the state's motion, but actually I think I will go back in and issue an amended order that will be effective in both cases. I'll notify Mr. Pryor of that so it doesn't come as a surprise. We've already had that discussion with him, but based on the findings of this hearing, I think it's appropriate that we clarify those orders, make sure they allow the defense counsel to have adequate access to people necessary that are assisting them in the case.
Very good. Thank you, Your Honor.
Okay, and then that would apply as well to the state using their resources as well in prosecution of the case. So I will work on getting a redraft of the protective order issued in both this case and Mr. Daybell's case, and we'll submit those into the case and serve those on counsel. All right, is there anything else we need to take up on the hearing today then from the state?
Not from the state, Your Honor. Thank you.
All right, thank you, Ms. Blake. Mr. Archibald, anything further for the defense?
No, Your Honor. Thank you.
All right, thanks for your attendance, everyone. We'll be in recess.